Greetings. My name is Tim Burke. I'm the county attorney, and I appreciate you taking a few moments to learn about what our department does. The county attorney's office is currently staffed by the county attorney, which is myself, and we have 2 additional assistant county attorneys, as well as 3 support staff members. We have no deputy currently, so I supervise each staff member directly. We have a budget of $716,270 per year, which sounds like a lot, but when you're running a law office, really isn't. Each county department has a mission, and the mission of the Department of the County Attorney is to provide the highest quality legal representation possible to our county commissioners, our county boards and commissioners, and our fellow employees. We like to practice what is called preventative legal measures, which would avoid you from getting into legal disputes, much like preventative medicine avoids you from having future medical problems. In addition, we want to make sure that everyone is treated fairly and that all county legal documents, contracts, and the like are of the highest quality. As stated earlier, what we do is provide legal county counsel to the county commissioners as well as our fellow employees. And some of those legal services include collecting delinquent taxes from our citizens where we've exhausted all other remedies. And we handle real estate matters on behalf of the county. The county is often buying and selling property or easements. We also help with our Department of Citizen Services in helping with our senior citizens. They do a wonderful job with our senior citizens when they have nowhere else to go, and we provide legal representation to them through guardianship petitions and whatnot. We also represent our sheriff. Our sheriff is our independent constitutional officer, but he often requires legal help, which we will provide in certain instances. Finally, we coordinate with our other county departments in ensuring that we are complying with the Public Information Act, which I'll talk about later, and our Open Meetings Act. Now, I mentioned real estate earlier, and much of what we do involves the agricultural preservation program for Carroll County. Once the documents have been negotiated with the property owners, it's turned over to the Carroll County Attorney's Office, and we prepare the legal documents. We work with the property owners to make sure the documents say what they have agreed to, and we actually handle and schedule settlements on the real estate matters. So we actually cut the checks at the end at a settlement. In addition, when the individuals are developing land in Carroll County, they often go through the subdivision process or go to the Planning Commission. One of the conditions of the Planning Commission is that the individuals enter into a subdivision package, which includes, in many cases, stormwater management easements, forest conservation easements, roadbed transfers to the county. In each of these cases, the County Attorney's Office, is the one who drafts the public works agreements and any other legal documents, including the easements that are required as part or a condition of the approval for the land development. We also handle public hearings when there is a requirement for one in state law, for example, in ordinances, or where there's a master plan of some sort is being adopted. Oftentimes, a public hearing is required. The County Attorney's Office works with the particular department and ensures that all legal requirements for the public hearing are met. Finally, we do draft bills for our county commissioners that are submitted to the General Assembly. Those bills are, in the end, written by the Attorney General, but oftentimes the commissioners will ask our delegation to submit a proposed law to the legislature for their consideration. And in those instances, we draft the initial draft of the state law for submission to our delegation. Now, there are some things that we're not allowed to do. We can't provide private legal advice to our citizens. So we couldn't draft a will for you. We can't handle your divorce. We can't represent you in disputes with your neighbors on matters that don't involve county ordinances or laws. We are also not affiliated with our court system. We are there a lot, we're practicing there a lot, we're appearing in district court and circuit court, but we're not a member of the court administration. So we can't give you advice as to how your case is proceeding or when things are going to be scheduled or where your case is headed. And finally, we do not prosecute criminal cases. Those are handled by the state's attorney. He is a independent state office whose job it is to handle crimes, prosecution of crimes. So if there's a crime, it's going to be the state's attorney versus John Smith, for example, and the county attorney is not involved in any state prosecutions. Sometimes we're witnesses, but we are not part of the prosecutor's office. He is completely independent. Where did the county attorney's office come from? The county attorney's office was actually created by state law. State law requires that Carroll County have a county attorney. And as one of the commissioners reminded me at one point, the state law requires you to have a county attorney. They don't require you to have this county attorney. So anyhow, Carroll County is required to have a county attorney. And in addition, there are several other bureaus and departments that are required by state law, which we are required to provide legal representation to, including some what are called quasi-judicial boards. Those are court-like commissions, like your Board of Zoning Appeals, your Planning Commission, your Liquor Board. We provide legal representation to them. We sit with them during their hearings, and we assist them in drafting their decisions once they have made an oral decision. Again, by law, we are unable to provide private legal representation to any of our citizens. However, that doesn't mean you shouldn't call the office if you have a question. If we can't help you, in many cases, we can direct you to where you need to go and give you a phone number or a person to talk to. As I mentioned earlier, we have a staff of 3 attorneys. And what we do is we break up our county into departments, boards and commissions, and we assign the attorney to a particular department or board or commission, and they provide the legal representation to them. They draft the documents, they sit through whatever hearings are needed, and they provide whatever legal advice is needed by the department or the board or commission. We have, as I said, a very hard-working support staff, and they're often the ones who work directly with our citizens in attempting to collect monies that are owed to the county for taxes, for example. When we've exhausted all other options, we often have to go to court to collect delinquent taxes. Even in those instances, we work with our citizens to come up with an equitable solution. There are other sorts of cases that we handle. There's vandalism cases. There are cases involving the destruction of county property, like guardrails or things like that. We also correspond directly with citizens and attempt to collect those debts. If we're unable to collect them by any other means, we do go to district court to collect those from our citizens. We also handle, as I said, all of our real estate matters. Any real estate matters and settlements are conducted by the county attorney's office, and our support staff is instrumental in handling those as well. The county attorney's Bible, if you will, is called the County Code. And the County Code is available online or in hard copy, and it's broken up into 2 sections. The first section is called the Code of Public Local Laws for Carroll County, and that is actually a compilation of state laws enacted by our General Assembly that pertains solely to Carroll County. Some examples of that are the state law that required the county commissioners to be elected by district and to number 5. That was a major change of state law several years ago. In addition, we recently had a state law enacted that enabled us to create a fire and emergency services department. The second half of the code is called Ordinances. Those are ordinances, those are local laws that were passed by the county commissioners or present and past county commissioners. And some examples are the noise control law, the animal control law, the zoning law, subdivision regulations. Those are all laws that can be repealed or amended by our Board of County Commissioners. Like the Code of Public Local Laws would have to be repealed or amended by the state legislature. Why do we need a county attorney's office? Well, number one, as I stated, there are several departments and commissions that need representation, and that they need a county attorney's office that is knowledgeable of all county government as a whole and county regulations. We need an in-house counsel versus an outside counsel. I believe that's the case because expense alone would dictate that. Counties and towns often employ outside attorneys at a rate of $300 to $500 an hour, which, as you can imagine, could get very expensive. We are here 8 hours a day at least and provide immediate legal access to the county commissioners or our departments at considerably less than $300 to $500 an hour. And we're also able to cross-train each other so that there's always an attorney available in our office whenever you call or whenever the county commissioners call. In addition, we believe we're saving money by ensuring that the county commissioners and our departments and employees are following the law. The failure to follow the law can result in fines, penalties, and other undesirable results for the county in such an event. Lastly, I did want to talk to you about the Public Information Act. The Public Information Act is a state law that was adopted in Maryland and in many other states in response to the Watergate scandal. It was an effort by the state legislators to give the public some access to what goes on behind the scenes in government. And they do that by giving the public access to governmental records upon request. Under the state law, anybody can request a public record from Carroll County government for any reason. You don't have to disclose a reason, you don't have to disclose your name, and the governmental agency is not allowed to even ask you why you're asking for this document. In addition, there's some strict compliance regulations set forth in state law that governments, including Carroll County, have to follow once we receive a Public Information Act request. Once we get a request, we can either produce the document immediately if we have it handy. For example, if somebody requests a copy of a permit or a copy of an ordinance, we should be able to hand that over immediately. If the documents are not readily available, then we have 10 days to either compile the documents or to let the requester know that we're going to need some additional time, up to an additional 20 days to produce the documents. And during that time, we've got to compile the documents, make copies or put them in the form requested by the citizens, and produce them within 30 days of the request. Notably, we do not have to create documents in response to a Public Information Act request. We only need to produce documents that are in existence. And I want to give an example, our Bureau of Permits and Inspections. They are bombarded with Public Information Act requests, usually up to 10 per day, and they, in most cases, immediately apply as the documents are readily available. They don't even come up to the county attorney's office. In many cases, some requests involve documents that are privileged or otherwise should not or cannot be disclosed. In that case, we conduct a review and determine which documents can be disclosed under the Public Information Act in response to a request. Currently, what's going on in our office? Well, we're handling about 50 land acquisitions, including a lot of ag preservation easements and some other public works land acquisition projects. We are processing or have processed up to 227 subdivisions and related files. In other words, 227 proposed developments are being processed through this office. We currently have 243 collections files opened. Those are bad checks, delinquent taxes, accidents, vandalism cases. We have 243 of those collection files in progress, many of which will end up in court, unfortunately. We also have 19 permit and zoning violations. When the permits office or zoning office has worked with the property owner and is unable to get compliance with their particular code, the matters are referred to the county attorney's office. We then attempt to work with the landowner to get compliance with the law, and if we're unsuccessful, unfortunately, we too have to go to district court for those. Also, we have 28 guardianship matters currently active. That is where the county has assumed the guardianship of the person, of a senior citizen or otherwise incapacitated person, because no one else is available to do it. We are managing with the Department of Public Works 110 leases of public property. Those are leases involving our property, which are being farmed or otherwise rented out to members of the public. And finally, we are reviewing hundreds of other contracts, agreements, purchasing documents, and other type documents for legal sufficiency. That's just a small sample of what we do here in the county attorney's office. I urge you to give me a call at 386-2030 if you have any questions or need additional information, or my email address is also available. I look forward to hearing from you and look forward to working with you in case you need our services in the future. Thank you.